right.
Cool. All right. So I'm here to welcome you. We are going to have many more people coming. They're probably getting off work and will be joining us shortly. For those of you who don't know me, I am Professor Jessica Silby. I am a faculty member here at the law school, and I also am the director of the Center for Law Innovation and Creativity, which we affectionately call CLIC here at the law school. It's one of the 3 centers of excellence at the law school, next to the Health Center and the Center for Public Interest. CLIC is a research and educational, hey, come on in. CLIC is a research and educational center where we focus on the study of intellectual property, tech regulation, information law, and privacy, with a focus, which is Northeastern University Law School's focus of, in the public interest. And we do programs like this with great colleagues like this. We try to do them at least once a month. The first, in September, we had a program with Professor Anjali Vats from Boston College on the role of race and IP regulation. Last month, we had Professor Jane Anderson, who is an NYU professor who's working on trademark and certification marks to help indigenous people's sovereignty rights and cultural rights. And this month, November month, is inaugurating failure to function. And the problem of trademark registration with this very austere panel. And with that, I leave it to Professor Susan Montgomery to introduce the panel.
Well, first I'm going to introduce David, who's going to, we have 2 co-sponsors for this event. So the other one is the Boston Patent Law Association.
Thank you very much. I'm Michael Bergman here for the Boston Patent Law Association. I'm the president of the club this year, and I want to thank you all for coming and welcome you, and thank Susan Montgomery, who is the chair of our law school committee, co-chair, and John Welch is a member, I know. And the Boston Patent Law Association is an association of about 1,900 members in the Boston area, all interested in intellectual property. We have presentations going on regularly, a couple of months typically, and we would welcome your interest if you would like to reach us, BPLA.org. So thank you very much for coming, and thank you, Susan, for arranging this.
Thank you. And I am Susan Barbieri Montgomery, and I'm a member of the faculty here at the law school and also at the business school at Northeastern University. And I'm really delighted to be moderating this panel. We have 4 panelists who have a lot to say, and a lot of examples, and a lot of slides. So I want to first, I'm going to introduce you to each of the panelists right off the bat. And then I'll sort of give you an idea of what we're going to do to get as much discussion as we can about this really interesting topic. Come on in. Glad to have you. So on the panel we have, I'm going to say this is the order of appearance, even though it's not the order of seating. So first of all, Professor Alexandra Roberts, who is on the faculty at UNH School of Law. And the author of this, right, the May 2019 Iowa Law Review article that happens to have the title Trademark Failure to Function. And so you can imagine that she has a lot to tell us about that. She's also familiar, I think, to some of the students in the room, a familiar face, who have taken her course when she was teaching the course here. Then next we have John Welch. You put your hand up, John, because I'm not doing it right. Thank you. And I suspect that many people in this room know of John, if they don't actually know John. He is the founder, and I used to be able to say the only writer, but in the last year or 2, he's been kind enough to allow some others to occasionally guest write the TTAB blog. And I am proud to say that I knew John when he started it, when both of us were only 5 years old, right?
15 years ago.
Yeah, 15 years ago, yeah. And he's also counsel at Wolf Greenfield here in town. He is a font of wit and wisdom, which those of you who practice know is a rare and wonderful combination in a colleague. And I have been fortunate enough to practice with John and do other things with him from time to time. He's also going to be familiar to some of the students who are here in the room because he has been kind enough to participate in and be supportive of IP CoLab, which is the law clinic on campus that provides intellectual property support for entrepreneurs and innovators. And he's also guested in numerous classes, so he's known to many faces. And next to John is Josh Jarvis, my colleague in black. He is also a colleague that I value for his wit and his insight and his flair. And he is, some of the students will recognize Josh from being on co-op at Foley Hoag, where Josh is a partner, or because Josh has also been kind to volunteer as a judge in moot courts, in INTA moot courts. And then the fourth member of our panel is Dan McKinnon. Dan is the head of global brand protection and senior counsel at New Balance. He's our in-house wisdom on this panel. He's noted for leading a company's enforcement efforts in China. I think he's gotten a bit of press on that. And I understand that that led to the highest IP damages award ever in China. Am I right about that?
For trademark.
For trademark.
Yeah.
For trademark. And also WTR's Best Corporate Brand Protection Team Award, a big deal. I also found a quote looking for him online and where he'd given other interviews, and he said it's important to be intellectually nimble and creative, and I thought that that's really something that a lot of people who practice in this area find is important. But he also has a sense of humor that he brings to this as well, including using a scene from Eddie Murphy's Coming to America to illustrate his evolution of his thinking about brand protection. And if we have time in the Q&A, you can ask him how he did that. So here's the plan. We're going to start, like I said, we've had a long conversations. The panel has a lot of really valuable insights, a lot of things to say. So the plan we came up with is that they're each going to start with some opening remarks. Certainly not everything they know on the subject. So what they chose is for some opening remarks, about 10 minutes each. And then we'll give them a chance to have a dialogue among themselves and in a discussion with you about maybe expanding on some of those points or commenting on each other's points, and also, of course, have time for questions and answers from all of you. Questions from you, answers from them, I guess. So the lead off is going to be Alex, who's going to give us a foundation and for this discussion, and then John is going to talk about TTAB focus and some recent trends. Josh is going to talk a bit about strategy. Dan's going to talk about the real world of in-house brand protection. So that's our plan. Now, you each need to turn on your speaker, right?
I turned them on.
Okay, they're on. Oh, and I should take a moment to thank Brad, who makes all this happen, and it'll be taped because of him, so you'll be able to get it. And you can all see here the slides, and you have that here. So you're all set? Okay.
All right, thank you so much for organizing this panel, Susan, on frankly one of my favorite topics in trademark law. I'm going to start with some background on failure to function, talk a little bit about why fact finders get it wrong and what kinds of approaches might help them get it a little bit more right, how they could do it better. So, use as a mark is a requirement for trademark rights, for establishing trademark rights. The requirement comes from the Lanham Act definition of what a trademark is, what a service mark is. It also comes from the common law. So essentially, any kind of thing, right, used to identify and distinguish goods and indicate source. So that use piece, use in a trademark kind of way, is built right into the statute. Rights require not just distinctiveness and not just use in commerce, but also that kind of use in a trademark way, use as a mark. This is our classic Abercrombie upside down pyramid. We've seen it before. I think this is often where we start. I think it's too often also where we finish. So it matters not just what the mark is, but what the mark does. What I want to do today is kind of problematize that bucketing, that assumption that, well, if it's not descriptive and it's not generic and it's not barred under Section 2, then we're good. We've got a trademark. There's a piece missing from that. So what I argue in the article that Susan mentioned is that use as a mark and distinctiveness are interdependent. So they both ask, will consumers perceive this as a mark? And distinctiveness actually affects the use assessment. The solution that I propose is to consider them together. That's especially true for two categories of marks. The first is those kind of like borderline descriptive marks. Is it distinctive or isn't it? And then the second is marks that are primarily something else. And I'll talk more about that. Those are categories of marks that are especially likely to fail to function, but any kind of mark can fail to function. What does use as a mark look like? It looks like use in trademark way, like a trademark doing its job, right? Communicating source, telling you who makes something, distinguishing from competitors. It's the type of use that consumers are going to view as a trademark use, which sounds super tautological, but we can kind of layer some concrete indicators on top of that. What does failure to function look like? Oh, I can see my slides, cool. Use as a book title, use on an invoice, right? Use only as a business name. Also this kind of descriptive use. So see here where it says refreshing, peppermint, plain and simple. This kind of informational, descriptive type use. A couple of TTAB examples. You can't even see them, they're so tiny. Where content reigns in semiconductor light matrix. Failure to function can also look like this. So the two images on the left are from applications to register, kind of the outline or the shape of, one is a chevron, I think they call it a pole spanner, that's where you pump your gas. The other one is the shape of a Wendy's sign, and the board said, look, the real thing may be a source indicator, but that's the way that people encounter it. When you strip away all the colors and all the text and all the images, that no longer creates this kind of separate impression. The image on the right actually, there is a successful registration for this whole image as a logo. And the owner then decided to also separately register just the dropper and the droplet. And the board refused and the Federal Circuit affirmed, and the Federal Circuit said, you never use the dropper and the droplet alone. Why would any consumer think that the dropper and the droplet itself functions as a mark, is a trademark, right? I mentioned primarily something else marks, so this is like your hashtags, your domain names, stuff like that. I'll give you a couple quick examples. Hashtag be unprecedented. I have a whole paper in California law review about hashtags, so I did a really deep dive here on every hashtag trademark ever registered at the time I wrote the paper. This one is a registration that belongs to LexisNexis for legal research services, right? I think it's garbage. I think when people see it, it looks like use as a hashtag. It doesn't look like use as a mark. Kim Kardashian West, yeah, obviously, her name is associated with her, but these are images that come from the specimens she submitted in support of that application to register her name as a service mark. They don't really seem to be doing what a trademark is expected to do. This is Make America Great Again. These also are pulled right from the specimen on file. This is a successful registration. This one occurs at the intersection of what I consider two different types of failure to function. So the first one is kind of context-based, use-based failure to function. That's the one that I'm focusing on in my 10 minutes and then I focus on in my paper. The other one we can think about as incapable informational matter or informational slogans. The USPTO calls it by a couple of different names. I think John is going to talk about this one a lot more. But so this is at the intersection of a type of mark that the PTO often says just isn't even capable of serving as a trademark ever, right? This is like your I love DC, your drive safely, those types of marks where the office just says, no, this phrase is too commonplace. And then on the other hand, we also have what looks to me like context-based failure to function, right? Just an ornamental use. Use on bumper stickers, use on the front of t-shirts. Those are not the types of uses that consumers are going to understand as trademark uses. Okay, so what can we talk about? What can we look for when we're trying to evaluate use as a mark? Is it big? Is it in a different color? Is it in a different font? Is it kind of stylized in some way that sets it apart? Does it have a frame around it? Is it featured prominently? Lee Christensen and DeRosa call this the trademark spot, right? So if you're looking at a hoodie, if you're looking at a t-shirt, for example, we know, theoretically, if you put a word or a phrase really big right in the middle of the t-shirt, that's likely to be deemed an ornamental use. But if you shrink it down and you put it by the breast pocket, or you put it kind of right on the edge of the sleeve, those are also trademark spots where consumers might look. And then best of all, easiest of all, in the tag in the back of the shirt, right? Once you put something there, that looks like a pretty clear use as a mark. Is it set off by itself, separate from other stuff? Does it use a TM symbol, a circle R symbol, all caps, initial caps? So there are all these kinds of different ways that the user can draw attention to the mark. The more of these indicia we have, at least for word marks, the more likely we have use as a mark. The fewer of them we have, the more likely that the matter fails to function, right? And there is empirical data to back up the idea that these indicia of use play into whether consumers are going to perceive matter as a mark. Excuse me. So Lee Christensen and DeRosa did this study a couple of years back. They found, hey, most consumers do perceive even a descriptive term as a mark, even a descriptive term they've never seen before, as a mark if it has enough of these indicia of use. So they took Wonderful, which was just kind of randomly generated, they put it on a box of cookies, and you can see it's got an oval around it, it's got shadowing, different font, different color. It's made to stand out in all these ways. 80% of consumers thought it was a brand name. Took away a couple of those, the oval, the shadowing, 70% still think it's a brand name, right? That kind of goes against some of our teaching when it comes to distinctiveness. Then they stripped away a bunch more of those indicia of use, and we get down to a third or even less than a third understand Wonderful to be a brand name. So you can see that the type of use, the way in which the matter is used, is doing a lot of work here. So again, the less inherently distinctive the matter is, the more robust use must be for consumers to perceive it as a mark, and vice versa. I'll give you a couple more examples where I think the board, here's an example where I think the board did it right, where these two questions come together. So the mark in this case is Trulicity. I don't know if you can even find it. I think you can see it a little bit bigger than I can, right? 0.5 milliliter solution for injection of Trulicity, dulaglutide, or placebo. And the use there is somewhat minimal. It starts with a capital, it has a TM symbol at the end of it, but that's about it. So we would call that kind of like bare minimum use as a mark. And yet the mark is fanciful. So the word says, hey, Trulicity is a completely made up word, nobody's ever seen it before, it doesn't have any other meaning to people, so there's really no other way to perceive it. So we feel good expecting that when consumers see this, we got a fanciful mark with minimal use as a mark, they're going to understand it to be a mark, right? There's no failure to function here. On the other hand, this is something I just pulled from a file wrapper. This was a specimen in support of a successful registration, if I remember correctly. The mark, if you can find it, is chipset-free charging. And it's got about the same indicia of use as Trulicity. Starts with a capital, has a TM symbol, and it's also in italics. But it's also really buried here among descriptive text, it's kind of listed among the other specs, and it's descriptive, right? Chipset-free charging seems like it's giving you information. So I think when you combine that bare minimum use as a mark with what is probably at best merely descriptive, this should have been a no. This should have been a failure to function refusal. Okay, so what? The dangers of overprotecting matter that fails to function. Hopefully we can all agree that granting registration or common law rights for matter that fails to function is to be avoided. It may be your client today who's facing a failure to function refusal, but it may be your client next week who's on the receiving end of a cease and desist, bolstered by a registration that the sender never should have received, right? So overprotecting matter that fails to function increases deadwood, creating a trademark thicket in a time when scholars have noted that we are literally running out of marks. It ties up descriptive language. So newcomer, new competitors trying to break into the market, who's looking for a mark to use, is unnecessarily limited in the marks available to them, and also unnecessarily limited in their choice of descriptive language when it comes to choosing language to put on packaging that explains what's inside, or selecting language to put in an advertisement, right? So a lot of unnecessary limitations. It even sometimes trickles down to consumer speech. And then overprotection also gives fodder to bullies, right? We know that for a small company that's under-resourced, receiving a cease and desist is pretty scary. Then when you attach a federal registration, or 5 federal registrations, or federal registration that's incontestable, that becomes pretty intense, right? We know that the vast majority of trademark disputes are not litigated to decision. They are settled, they are negotiated over the phone, they are a cease and desist followed by the recipient just caving and giving in. So registrations cast a really big shadow and have a lot of downstream effects, and I think that's something that we should be concerned about. I'm going to stop there and hand it over to John.
Thank you very much, Alex. John, you want to take that clicker? Oh.
No. I'm just going to read my notes because I had a hard time getting my hands around this failure to function problem, because there are so many different kinds of failure to function refusals and grounds for the refusal and analyses. So I just tried today to put my thoughts in some kind of order, and you'll have to be the judge as to whether I succeed or fail. But anyway, from my perspective, it seems like the number of TTAB decisions that involve failure to function issues is increasing. In fact, I talked to my old friend David Prosak, who's a longtime trademark attorney, and he agreed. He said he hasn't seen so many failure to functions in such a short period of time since his honeymoon. So I think
Do you have a slide there?
somebody laughed. So the TTAB gets only the cases that are appealed and the inter-parties proceedings that involve these issues, and the board has been pretty hard-nosed on the issue of failure to function. I think it tries to set some guidelines for the examining attorneys and practitioners as to when and how this kind of refusal applies, but trying to put together some overall approach that the TTAB takes, I think, is simply impossible. And every case is different on the facts. And of course, one can look at individual decisions by examining attorneys, and you can shake your head as to why this happened. But I don't think it's fair to say that the USPTO is lax in allowing registrations of words or phrases that aren't functioning as marks. Maybe the answer is the examiners need more training. And when the case goes to court, it's really up to the attorneys to educate the court as to what a mark is and what isn't functioning as a mark. Now, I understand what Alexandra says, that the problem is the interim effect of a registration that's issued. Most potential defendants don't want to go to court, so they receive a cease and desist letter and they get a threatened lawsuit based on what is arguably not a trademark. But as a practical matter, they don't want to spend the money at the time to fight it, so they yield to the demand. I also just want to say that I think the article about we're running out of trademarks is a bunch of crap. But anyway, it's good for trademark, good for a law review article. The failure to function refusal, of course, hinges on consumer perception. In other words, will a consumer perceive a word or a phrase as an indicator of source? Of course, trademark examining attorneys have no way to survey public opinion or to conduct a survey, so they rely on dictionary definitions and look for third-party uses of these words or phrases. It's certainly conceivable that an applicant could offer a survey, but as a practical matter, just because of the expense involved, it's hard to do a survey for less than $30,000, even an internet survey. It just doesn't happen at the examination stage. So what we're left with is basically the subjective judgments of individual trademark attorneys based on whatever evidence they compile together and whatever they think So what's the TTAB up to in this realm of failure to function? Well, I think it has two goals. One goal is to try to keep common phrases and words available for use for everybody in a particular field. So for instance, if one person files an application to register the latest internet meme as a trademark for T-shirts, I think the board had, at least somewhere in the back of the board's mind, if there is such a thing, they want to keep that. They want to keep that phrase or meme available to anyone who wants to sell T-shirts. So that's one approach I think the board takes. I think another goal that it has in mind when it looks at specimens of use is it's simply technically trying to enforce the rules for proper specimens and what a proper specimen is and where the mark has to appear. I think those are the two main types of failure to function cases that the board deals with. As to the first issue, making words and phrases available for everybody, this is sort of comparable to the generic refusal, where, of course, the board is not going to allow a generic term to be registered. In fact, it seems to be casting a wider and wider net and calling terms and phrases and words generic. For instance, blueberry muffin for beer was held to be generic by the board in the past year. Some really surprising decisions, because the board now finds generic a word or term not only that names the product or service, but names a key aspect or ingredient of the product or service. So, of course, the upshot of this is if you file an application and your proposed mark is deemed generic, that's the end of the story. You can't prove acquired distinctiveness, you can't show that it's become a trademark, you're dead in the water. Well, the same thing is true with failure to function refusal. You get a refusal that says, store your phrase, let's say drive safely, is never going to be a trademark. It can't function as a trademark while you're dead in the water. There's no way you can get on the register through acquired distinctiveness. So the failure to function refusal is really fairly draconian, and one could ask why the board has to take such a draconian or severe step for these marks and phrases rather than say, well, they're not inherently distinctive and you have to show acquired distinctiveness, and in light of the fact that this is a common phrase, you have to show a lot of acquired distinctiveness. You have to have a lot of evidence. But the board hasn't gone in that direction. For instance, going way back to the case of the best beer in America, it simply said that can never function as a trademark. No matter how much evidence you put in, or if you do a survey, you can't even get a survey in. So that's one issue that the board has simply it just, for some reason, it likes the failure to function refusal and is trying to keep, as I say, keep words and phrases available for everybody. Most often, the board's cases on failure to function deal with clothing or printed materials, so that you're already leaning towards informational matter or an internet meme. When it's a use-based application, of course, as Alexandra says, the board will look at the specimen of use and see how it's used on the specimen. In the Walmart case last year, the board decided that the phrase investing in American jobs fails to function as a trademark based on looking at the way Walmart used the phrase. They used it on shelf talkers, but more importantly, they used it on their website where they described their actions toward bringing jobs, keeping jobs in America. So by looking at the specimen of use, the board decided that that was merely informational, doesn't function as a trademark. Now, even a proposed mark that's filed on the basis of intent to use can still fall victim to a failure to function refusal. For instance, if either for clothing, T-shirts, or for bumper stickers, you have an internet meme or a political slogan, the examiner is likely to say, well, that's fails to function as a trademark, and you can say, well, you haven't seen the specimen yet, and the examiner can say, I don't care, I don't need to see the specimen, it's a bumper sticker, and you're putting this phrase on it. As I say, on the specimen side of the issue, sometimes the term is inherently distinctive, but it's just not used as a trademark. It's, I think, the case where the mark is buried in the text on the label for whatever that publicity or whatever mark was. I think that was a really bad decision. I don't think that functions as a trademark at all, even though it's inherently a distinctive term when you bury it in a paragraph of text. I don't think that's a trademark. So I guess my point is, since the issue of whether a mark fails to function as a trademark is often so subjective, you're going to have many disagreements in individual cases. I think the real question is, should the door be slammed on the applicant, or should the applicant at least have an opportunity to show acquired distinctiveness? One of the cases, I think, that one slide I want to look at, if I can find the clicker, Josh took it, thank you, Josh, is this disorderly kids case, where this fellow named Atwood, like Rowan Atwood, I don't know who he is, and he's he's a YouTube star apparently. The board dismissed the petition for cancellation of a registration for Smile More for various goods, including shirts and retail store services featuring clothing, denying a claim of failure to function. Now this might give you some ideas as to how to overcome a failure to function refusal. The board said this is not a case in which widespread ornamental use of the phrase "smile more" by third parties may influence how the mark is perceived. So one argument is, hey, there's not many people using this. So why do you think the public perceives this as informational? To the contrary, the record evidence supports the finding that "smile more" is used in connection with the goods and services serves to indicate a source. Petitioner submitted evidence of a modest number of third-party uses, okay, for hats, stickers, and the like, but the record evidence also showed that Atwood actively and vigorously polices his "Smile More" mark and views such uses as infringement. He also had evidence of people writing to him saying, hey, Atwood, they're infringing your mark, you better go after them. So he had some pretty good evidence. Maybe "Smile More" isn't quite as ubiquitous as some internet names, but anyway, although his specimens of use in the underlying application display the mark in an ornamental fashion on his goods. Now normally, if that was the only product, t-shirts, he puts "Smile More" on the face of the t-shirt, forget it, ornamental, it's not functioning as a trademark. But actually, because he had the mark registered for retail store services, it's getting a little technical, he was allowed to register for t-shirts on the ground that it serves as a secondary source indicator. So sometimes you could have a mark registered, say, Olin's for chemicals, and you want to register Olin's for t-shirts, you can rely on the fact that it's registered for chemicals, and it's a secondary source indicator, which is a dubious validity. There it is. Anyway, that's all I have to say.
You know, John, someday we can maybe do a whole panel on t-shirts. I've won as a prize at a TTA blog event, a t-shirt which some students may have noticed hanging in my office. It's a red t-shirt and it says on the front, "This is not a trademark."
I already said it.
Very useful. Okay, so Josh, you want to pick up there?
I will pick up there.
And you can take the clicker. And
I have the clicker. I'm ready.
You're ready, all right.
So my job, and John's job, and Dan's job is in part to help clients choose marks or terms, I should say, that function as trademarks, that are protectable and enforceable and registrable. For the most part, this involves gently kind of pushing them towards the distinctive side of the descriptive, suggestive, arbitrary, fanciful spectrum. So I'm pushing them away from descriptive and generic terms and pushing them in the direction of suggestive and other distinctive terms. Usually the question of functionality, whether the mark can function as a mark, doesn't come up. Sometimes the threshold question presents itself kind of organically in the sense that if it's a common informational phrase like drive safely or buy one, get one free, I'm going to say, listen, you're not going to be able to protect this. It's not a brand. Stop. Just stop. Sometimes it's a model number or something that would not necessarily act as a brand. Sometimes it's t-shirt use, intended ornamental use that's going to be problematic. Sometimes we have specimens in front of us, and it's very clear that the mark as depicted on the specimen isn't really functioning as a mark. So we can fix that and say, if the mark is otherwise distinctive, we can say, listen, if you use it more prominently at the top of the page, then this will function as a mark. If not, it sounds like it's going to be a problem. The problem that I've been seeing lately with the failure to function issue is that traditionally I've seen relatively few failure to function refusals in the context of intent to use applications, otherwise ITU applications, as we call them in the biz, where the trademark significance issue, apart from its distinctiveness, apart from its raw distinctiveness, can't really be evaluated in a vacuum, or often can't be evaluated in a vacuum without seeing how the mark is actually used by the applicant. What I'm seeing lately are an increasing number of failure to function refusals in the ITU context. Some of these seem potentially reasonable. Many seem premature, and some seem just straight up wrong. So I wanted to just look at a couple of examples. I've taken a random or arbitrary and capricious sample of failure to function decisions that issued in October of 2019. So let's just look at a couple of these. So this is the mark Hot Boy Summer for apparel in class 25. So the basis of the refusal here is failure to function. The examiner says that this is a term or expression commonly used to refer to boys and men living their best lives this summer. and this conveys a common saying or message. So to rely on this failure to function refusal, the EA attached a single reference on the website stayhipwith2b's.com, which basically included this. It basically said that, this is a saying that refers to boys living their best lives, boys and men living their best lives, and this is the basis of the refusal. So it's interesting. In a vacuum, this does not come close to the type of mark, to the type of phrase that is so common as to fail to function as a trademark. Have any of you heard of the phrase "hot boy summer"? We got one.
Josh, I think this was
Hot girl
I think this
summer.
was about equal treatment, right?
So I guess people are using it as hot boy summer now.
All right, so apparently this may be known. However, it is not known so widely that it can't function as a trademark. Are you telling me that if this mark appeared on a hang tag for apparel, it could not function as a trademark? That seems unlikely. Now, I want to give the examiner the benefit of the doubt here, because I know what he's thinking. He's looking at the market, looking at the goods, and he's rightfully skeptical because he knows he's going to get a specimen that shows the mark on the front of the t-shirt. He's going to have to issue a refusal based on failure to function because it's merely ornamental. The problem is this is an ITU application. It can clearly function as a trademark. So in my opinion, a failure to function refusal should not issue until the applicant files a statement of use and demonstrates that the mark is failing to function. If not, then the only way the applicant can respond to this is to argue that, well, I intend to use it as a trademark, and there aren't that many references, and there's no real standard to respond to this. It's a frustrating situation for this, I'm sure, good faith applicant who intends to use it as a brand. So let's look at another one. This is another quick one. Sis, this is your man for apparel in class 25. Refused as informational that merely conveys the support of admiration for or affiliation with the ideals conveyed by the message, namely that this refers to possible cheaters. So this is a similar situation. In fact, I think this is a closer call because Sis, This Is Your Man is a little bit more widely known, I think, than Hot Boy Summer. But still, I think that the failure to function refusal is premature. This is an ITU application for a
Maybe you should combine the two.
This Is Your Man and the Hot Boy Summer. Here's one that does not have anything to do with apparel. The mark is velocity to value. These goods and services are informational technology, or I think it's information technology services and consulting in class 42. The examiner refuses registration on the basis that it's a commonly used term to convey a meaning of acceleration toward a return on investment. So here the examiner identified a few references. Some of the references appear to be trademark use. Others appear to be possibly merely descriptive use in context. But a direct hit search for the mark yields just over 24,000 hits, which for a Google search is not that many. And the 24,000 hits don't show that the term velocity of value has any particular meaning. So it hardly seems common enough that it per se fails to function as a mark. So I think that at the very least, again, this is premature because we don't know how the applicant intends to use this potential mark. Also, if the applicant intends to use it in a way that ends up being merely descriptive, then mere descriptiveness is probably the correct basis for refusal and not failure to function. The failure to function refusal, like John said, it's draconian. It tends to shut down arguments because there's very little the applicant can say other than argue that 24,000 hits isn't that many, and listen, we intend to use this as a brand. So with a mere descriptiveness refusal, or even with a genericness refusal, applicants can rely on established tests and a wide body of case law to develop arguments as to why the mark is registrable. And on the flip side, the examiner actually has a burden to meet. If it's generic, the examiner needs to put into the record evidence of genericness. With the failure to function refusal, it's like, I found a couple references and it doesn't seem really to function as a trademark, so I'm going to put this in your court applicant. So this is really difficult for an ITU applicant to overcome. Just a couple more. 1 minute, one more. Hold on, I'll see.
Pick your favorite. You can come back to it.
I'm going to come back. This is pretzel-roni. Pretzel-roni is, the goods and services are cheese and pepperoni in class 29 and soft pretzels in class 30. The basis of refusal is failure to function because this is commonly used by those in applicants' trade or industry to merely convey information about the applicant's goods or similar goods. So here's the thing. The examiner here submitted a few websites, maybe 5, to show pretzel-roni used in a way that may be generic, but far, far from conclusive on the point of genericness. A search for pretzel-roni on Google has 194 hits. For a generic term, it would usually be more than that, for a known generic term. And I'm not saying that a coined term cannot all of a sudden become generic, because that is possible. It's unlikely, though. So here the examiner kind of kicks, he just kicks away the genericness issue. He doesn't have time. It doesn't look like he's going to be able to support that. So he issues a failure to function refusal. If a genericness refusal is appropriate, then the examiner should issue a genericness refusal, not failure to function, because then, at least in that situation, the applicant has a roadmap for arguing against the refusal. Also, pretzel-roni seems unlikely to be generic for cheese in class 29.
Plus, it could be pretzel-roni.
It could be.
It could be a guy who's made out of pretzels.
Yeah.
And then he's pretzel-roni, and you don't even get a chance to submit that specimen.
There are any number of possibilities here. So I have a few other examples, but let's let Dan.
Pass it to Dan.
Dan speak, and
Sure,
maybe I'll come back someday.
Because I'm looking forward to a pretzel-roni. Sounds delicious.
I didn't get to sass hole.
If you click a few, Dan, you'll get to your
I'll
slides.
get there eventually. So I did 4 whole slides. And one of them is just New Balance. How about that? That's where I work. So I wanted to talk just briefly a little bit about, I was super honored to be able to speak here today, but also super felt like I was out of my league. I was like, that I'm in-house and I don't really follow the law that closely anymore. But with that, I got a quick crash course, and I was ready to be here and strategically placed last because I knew that my colleagues here would have covered everything, and now I can just sort of talk about what I do. But yeah, to the point, here's a real life example. So this is us. I'm in-house, so I'm working for my client at all times. My client is New Balance. I'm also working for New Balance, so I am my own client. So we are asked from time to time to register trademarks that we know, this is not going to work. And one of them is this thing, Valley of Ashes. This is done by our tennis department. They came up and they said, hey, we made this t-shirt. It's called Valley of Ashes, and it refers to basically what's going on at the U.S. Open. The U.S. Open is oftentimes referred to the Valley of Ashes from the famous Scott Fitzgerald book. And so they thought it was very clever, they thought it was great, and they put it on our star athlete, who at the time, I think he was like 7th or 8th in the world, had a real chance of winning, and boom, blew up. Everybody wanted these. They thought they looked cool. And so they said, we're going to trademark this. And I said, okay, well, we've got our use. We've got a use-based file. Just give me a specimen. And the picture you're looking at is the specimen I received. I said, I can see it's coming. This is an ornamental rejection from day one. But you know what? All right, we'll do it. Of course, the quickest rejection ever received. Ornamental, boom, back in your face. So now I'm like, okay, I told you this was going to happen. So it kind of got me thinking, and that's one of the dangerous things. You don't want to get me thinking, because, and I started saying, well, I could get this probably registered if I just, did the old, let's squeeze that. That's logo-ish looking if we really shrunk it down and put it on the breast. Yeah, let's do that. And then I was like, no, let's not do that. And the reason why is I sort of wanted to address a topic that is something I can talk about outside of the brain power here, and it's just my kind of thought and something I would bring to the table here tonight is, how do we approach trademark law and filings in particular and prosecution from more of a philosophical standpoint? What I mean by that is, we know the tricks, we know the things that we can do to serve our clients, but are we really maybe cutting against the spirit of the law when we do those tricks? And that's a sort of a philosophical question we have to ask ourselves. There's a great quote I like to say all the time is, a halo need only fall but a few inches to become a noose. So I'm not here to tell you, preserve the law, the spirit of the law, and tell your clients, they're eroding the trademark law if you force me to shrink this and put that on that breast pocket, because it's still not a trademark, even though it's going to get through. But if you indulge me for just a minute and give me some latitude here, I'll show you why I brought this up. Is because for all the frustrations we feel here in the US, the USPTO does an amazing job when you compare it with the Chinese trademark office, which is atrocious. Let me give you a quick example. But the example comes back around. So indulge me for 1 second. I only have 4 slides. This is the last one. All right. So that's our block N. And when I was first starting at New Balance 13 years ago, my job was to register that mark in all the countries that we do business in. I was a block N, like just a capital letter N. You want me to register? They're like, yeah. like, do you know the volume of required distinctiveness it's going to take for me to get block N registered in Taiwan? Let's do it. So we go, and finally we did it over many years, and we've got this registered, and we're using it in all these countries, and we've grown and we've become quite successful. But in China, they're really, really tricky, and they love to figure out ways that they can get trademarks. And this is what they did to us recently. That top mark is for footwear and apparel. That bottom mark, that's also for footwear and apparel. But those marks were actually filed by the same company months apart from each other. And then, because you don't need a specimen to be used over there, then we started seeing these shoes show up in the market. And we were like, oh. We knew someone was up because we recognized these guys are bad, but we couldn't quite figure it out. And we were like, there it is. That's the game they're playing. They're slicing up trademarks, registering them individually, and then putting them back together in certain locations to convey a different mark. And then we go in and we try to bust these guys for counterfeits, and they say, no, actually they have these two trademarks. And there's no requirement as to how they work or where they are, but that's it, you can't get them. So, I go all the way back to this. I don't want to start doing those games personally, and so I think one of the things I ask myself with this is, when you're talking about does it function as a trademark, there's certainly some really bad rejections here, especially the premature ones. I don't even understand those. But one of the things I think is incumbent upon trademark attorneys too is to really remember, when it all boils down to the entire Lanham Act, everything we're doing is this going to function as a trademark? And in my mind, I knew how we were selling these shirts. We're selling them in packaging that says New Balance all over it. So the consumer knows they're buying New Balance. There's no trademark there. They want that shirt because it looks good. But at no point in time is it really a source of origin designator. And so we ended up just abandoning the mark. And that's a quick story from inside the walls of New Balance.
I would have thought it might be geographically descriptive of California.
Yeah. Ooh, ouch.
So that's a great, that pulling it back to like a philosophical level is really helpful, because there's been a lot of details, and there's even more, as I've warned you, if we look at all the slides. So I have a question along the philosophical line for the panel. And when we talked about this, and when we wrote the description for this panel, we talked about what's happening. Why is this happening now, right? So in Alex, the footnote in Alex's article that says, citing someone else's article saying that between 2003 and 2016, the USPTO issued 26,450 failure to function refusals. And if you look at John's site, I didn't look recently, John, but I think for this year you already have 30 to 35 TTAB. So those are people who appealed from those refusals. Far more refusals, and yet there's this huge increase. So philosophically, what's the USPTO up to? Why this increase? Did they listen to Dan and get religion and go back to first principles? What do you all think is where this is coming from?
Poorly trained examiners.
You want to say more about that? I know you feel that way.
Well, no, I think it's a combination of poorly trained. So, there have been significant numbers of examiners hired over the past decade. A number of them are in law offices staffed by additional recent supervising examiners. And I think that there is a failure to appropriately train a lot of examiners. That said, so I think that some of those examples I pointed out are demonstrative of poor examiner quality, or at least maybe a combination of poor examiner quality and examiners that are getting ticks unless they churn out office actions very quickly. I think there's a lot of pressure, so I don't want to put it all on poor training. I also think that it's a combination of that and, to its credit, the USPTO has been taking very seriously a number of problems that have arisen with respect to deadwood on the registry, fraudulent applications coming in mostly from China, but also from elsewhere, a glut of applications where there's clearly no bona fide intent to use, mostly emanating from the Madrid Protocol and 44E. So I think the USPTO is under a tremendous amount of pressure from its constituents to clean up the registry. And I think that, this is in part a side effect of that, appropriate action.
Well, I think also the easiness of filing trademark applications today and in the last few years, and also the explosion of social media sites talking about celebrities trying to quote trademark this term or that term. It seems like trademarks are in the air, and people think that if they can be first to the trademark office to file an application, they can own this phrase or they can own this word. So I think that's generated a lot of the problems and a lot of the refusals. But I agree with Josh that certainly is a problem with examiners not understanding what the refusal is. And I agree with you, Josh. I think maybe examiners should not be allowed to issue a failure to function refusal on an ITU application, at least in the specimen.
I mean, unless it's one of those categories where the failure to function is so apparent that where it's not dependent on ornamentality.
Your bumper sticker.
I mean, even then, it's but I mean, clearly when it's one of the what I like to call trendy trademarks, where it's where it's a filing that is filed soon after a world event or subsequent to a meme, whether it's Boston Strong or Covfefe or however you pronounce that, or Covfefe.
I think that was the French pronunciation.
There is no
Covfefe.
How did the president pronounce? Always a tweet.
There's a separate section in the Trademark Manual of Examining Procedure on informational slogans. And it seems right that you could get an informational slogan refusal on an ITU app, but it seems absolutely wrong that you could get any other kind of failure to function refusal. So to be clear, I'm not necessarily, in some ways I think an increase in failure to function refusals is a great thing, but I absolutely agree with you that they shouldn't be coming on ITU apps. It just doesn't make any sense.
Right.
Dan, what's your thought? And you need to get near a mic.
No, can you hear me okay?
Well, no, we're taping it.
Oh, okay, so I'll just, all right. Yeah, I mean, I think I agree with the general consensus. We had a call earlier and we all spoke, and I think I'm, schooled in the thought that almost anything can function as a trademark with the right amount of acquired distinctiveness. And so the idea that you're preemptively preventing that from occurring just doesn't sit right with me, as long as it just feels to me that anything we do could ultimately act as a trademark, because at the end of the day, you boil the entire Lanham Act down, and even the common law, it's just, is this acting as a source identifier? And if it does, I can't think of too many things that don't. And of course, there's generic refusals and things like that, but outside of that, I don't see it.
Can I ask a question?
Yes, please.
So my question really has to do with the use of all of these marks on T-shirts. And so, although I agree that the Valley of Ashes is an arbitrary mark to sell T-shirts, it's not designating the source of the T-shirts in any meaningful way. And so if you're allowed to mark your apparel with hip slogans, as arbitrary as they are, it does prevent anyone else from expressing themselves with a T-shirt. And so I feel like there's an implicit, like we have to wrestle with the expressivity of the slogan on T-shirts, separate and apart from whatever it was, Pizza-Roni for cheap. I mean, that feels different to me than the T-shirts. So can people address the T-shirt problem? I mean, is this a T-shirt problem rather than something else?
I think that the T-shirt is just more likely to be a failure to function problem. In fact, I think, the recent Fuke case in the Supreme Court, FUCP, that application was published for opposition, I think on October 3rd. I don't know if anybody opposed it. But anyway, I think that's an informational failure to function type problem. I think somebody could have opposed that on failure to function. It's expressing something.
Right.
Yes.
But,
I'm sorry, a counterpoint would be, yes, if you're filing something that's already out there in the world to such a degree that everybody says it, but if you come up with a unique slogan, let's say for a moment you come up with something and you put it on a Super Bowl ad, and then you put it on an ad for the Oscars, you're blasting it out there, and it's right in the middle of your T-shirt, and so I think it's again, it just always goes back to, is it acting as a source of origin designator? And so the point is, when you're talking about failure to function as a mark, when you're talking about these slogans like, I think LeBron James just got shut down for Taco Tuesdays, right? So Taco Tuesdays, of course not. I grew up with Taco Tuesday. Everybody knows Taco Tuesday. So it's in that type of.
but I think if it's on a T-shirt and merely ornamental, it still can have acquired distinctiveness. So if you have a slogan that you create and put on ads at the Super Bowl, and then you put it on a T-shirt, conceivably, if it's not informational or too informational, you can have acquired distinctiveness and register for T-shirts. But it's a problem when it's an informational, something informational.
Yeah.
That's the problem. That's where it becomes a failure to function problem rather than just a mere ornamental problem, which is overcomable.
I think there's a different conflict there too, which is that, as Dan indicated, you put something on the front of a T-shirt, you get an ornamental refusal. It's really, really easy to get past it by sticking it on a tag. And then maybe you do have use as a mark, maybe put out some other T-shirts, whatever. But theoretically, fair use doctrines should help you. So the problem then, I think, becomes a bullying problem, becomes an enforcement problem, where once somebody has that registration, it becomes really, really easy to stop anybody else from putting a phrase on a shirt, even if, if the conflict actually went to trial, we would say, well, that's a fair use, right? You're using that slogan in an expressive way and not in a trademark way.
I have other questions, but do you have other questions? Yes.
A couple comments on the ITU, putting a ban on ITU, failure to function. I think one of the reasons that would be dangerous is because it's so easy to make bogus specimens. You see it all the time. You see a T-shirt with a little hang tag with a safety pin on it.
That you can find, I have a case where you can find where the website where the guy made the specimen and the website where he got the specimens of use. I mean, you find exactly the hang tag, exactly the wooden floor background, and it says, take your logo and move it over the hang tag, and now you have a photograph of your hang tag.
So it would be a shame if there was if we eliminated the hurdles and you were left with, and I have a client that's in the online retail space, and we get these all the time, where there's a slogan, a stupid slogan, the kale slogans.
Eat more kale.
And let us be, what's the trademark?
Let us turn up the beat.
Oh, yeah, let us turn up the beat. So she goes around and she sends these letters. This is the person who registered Let Us Turn Up the Beat. It's on the T-shirt, but it's also on a hang tag. And so when she writes my client, I tell her what she can do with the trademark. But a lot of people don't do that, and they have a registration, and they do get scared.
Well, the hang tag doesn't necessarily solve the problem. I Love BC case involved a mark that was that was on the hang tag on these shirts, but the board still said it's so ubiquitous it fails to function.
Well, and there's wonderful language in that case that says, even though it's used on a label or a hang tag, doesn't make it a trademark.
Yeah, exactly.
Thank God.
Others? Any student questions? Yes.
Mine goes to the Hot Boy Summer one, and I'm curious because one of the most popular hip hop songs of this past summer was Hot Girl Summer, as she said. So it seemed clear to me that whoever is attempting to ride the wave of Hot Girl Summer into Hot Boy Summer. So how do you feel if that song never came out, the decision would have been different, or if they tried to register this before the song came out? There seemed to be a little bit of an overlap there. They must have registered it pretty much after this song Hot Girl Summer came out.
Yeah, so knowing that, I'm slightly less indignant about the refusal. Still a little bit indignant because I'm still not sure that it's an appropriately ubiquitous phrase as to fail to function as a brand for apparel. But with that context, that makes a little more sense to me. In terms of timing, I mean, certainly if it came out, if the application were filed before the song came out, it should matter. I'm not sure that it necessarily would to the examiner because they wouldn't necessarily know. I also wonder whether there could be some sort of trademark or false association claim with the songwriter or whoever owns the.
Yeah, I think that was an active issue for the applications to register Hot Girl Summer, because what happened with that, I don't know if anybody was following along with that, the singer announced that her people were on it and she was trademarking it, and an application turned up, and the application actually was not from her, and it was not from her team. It was somebody else doing what we've been discussing, which is just jumping on, this is a meme, everybody's using this hashtag, I'm going to win the race to the office. And in some cases with those ubiquitous catchphrases, you can win the race to the office. And in other cases, you end up with a false association issue, either a false association with the singer or kind of a likelihood of confusion with pre-existing common law rights, which is to say, if you use this, everyone's already going to be confused that there's some association with the person who sings the song, with the person who made this into a viral hit.
And a number of you in your comments pointed out the subjectivity involved in the examiner's review. And Josh, the lack of explicit factors or a clear test or clear guidance. And for something like this, okay, I had never heard of that. Okay, I was here all summer and I didn't hear the song, right? So, what's the chance of an examiner hadn't heard, right? And that's, I think Josh has offered one thing. I think maybe one of the things that will come out of this that we didn't really get to is, are there other proposals for clarifying? Is there a multi-factor test that should be developed? Is this something where the PTO should be asked to develop a better guidance in the manual? Is this something where people will march in, the right person gets burned and will march into Congress and say, we need to amend, there's no sub-part of Section 2 labeled failure to function. So we need an amendment. So we didn't really get into that. We don't really know where that's going. Instead, we talked about all these wonderful, amusing, and easily critiqued, I think a lot of them, examples, but for practitioners and for brand owners, this is where you are. This is where you are, and this is where we are now.
Are we out of time? I wanted to go back to the very first slide that Alexander has. We have the clicker there. You have the clicker? Oops. Oh yeah, this is section 45. It says the term trademark is any word used by a person to identify. It doesn't say perceived by the consumer as a trademark. Right. It says used by a person as a trademark. So if I'm using it as a trademark, where's the failure to function refusal come from? It's not statutorily based. This is a point that Ted Davis
Right. Ted Davis had brought this up this week, and John and I spent a little time last week hunting around in different, literally, pulling out the Lanham Act and looking everywhere we could to find it.
Well, our first reaction was, no, then we said, wait a second, it's Ted Davis, he knows what he's talking about. We better look at this further. But if you look at the language, it doesn't say it's perceived by the consumer, it just says used by a person to identify. So if I think I'm, I use this thing, I think I'm using it to identify the source of my goods.
So you're saying it should only be the intent of the...
Well, that's the
user?
question.
The consumer aspect of it is built into the words identifying distinguishes her goods, because it can only be distinguished.
I use it to identify and distinguish. Maybe I'm wrong, but that's what I think I'm using it for.
No, well, it doesn't say whether you think you use it. It says used it as, and the only proof...
I'm using it to identify my goods.
Yes,
it turns out,
but
that's
you may or may not
what
succeed in having it identify the goods, and that's where the use, that's where the perception of the consumer comes in.
No one listening
I
to this
say-
conversation could tell that we're lawyers.
This is
I
amazing.
think that the core of trademark law says that distinguishing is in the eye of the consumers, right? And I think that's why courts have repeatedly come back and interpreted this to require consumer perception of use as a mark, or the type of use that we expect consumers will perceive.
So I want to tie this up so you all have time to talk to our speakers, and I think we also, do we have some refreshments?
Yep.
Also? So I want to invite you to do that, but I think that you can all see that this is now something to follow. There's more and more of these refusals, more and more appeals to the TTAB. Going to go up, and so I think that you have questions you can bring up, and I promise you that all of our speakers have lots more to say, but we're out of time, so let's thank them.